We're good to go?
Hi, everyone. Thanks for joining us for this webinar on census litigation. I hope you all are staying safe and healthy during this pandemic. And as you know, Asian Americans Advancing Justice is working to ensure a full and accurate count of our communities in the 2020 census. And as a national hub, we created curriculum and materials to support your Get Out the Count work, including fact sheets, toolkits, webinars, social media graphics, translated materials, and more. And we hope that these resources were helpful during your Get Out the Count campaigns. Today, we're excited to dive deeper into census litigation, and we have an incredible lineup of speakers who will talk about the state of play with respect to lawsuits challenging the current administration's unprecedented attempts to cut short the 2020 census and to exclude people who are undocumented from being counted for the purposes of apportionment, and what this means for you and your communities. As you may know, this webinar is the 23rd installment of our monthly census webinar series, which we launched in August 2018. And if you missed our previous webinars and want to tune in, you can access them with the links on this slide and also the next slide. And we will continue to host webinars focused on the census through the end of 2020 as we wrap up our census campaign. This is our agenda for today, and we are joined by three wonderful colleagues in the litigation space. We have Eri Andriola, who is the staff attorney for litigation with Asian Americans Advancing Justice, AAJC. We also are joined by Andrea Centeno, who is the regional counsel at the Mexican American Legal Defense and Educational Fund, or MALDEF. And lastly, we have Sarah Brannon, who is the managing attorney for the American Civil Liberties Union, or ACLU's Voting Rights Project. We will have Q&A at the end of the webinar, and you can use the Q&A portal to ask your questions. And if you have questions during the presentation, please also use the Q&A box to send us your questions. My colleague Rima is running our Zoom technology today, so a huge thank you to Rima. This webinar is recorded, and we will send out the recording and a copy of the presentation after the webinar. And check out our census website at countusin2020.org for all of our webinars and the accompanying summary blogs for each webinar. And you will also find a new fact sheet on census litigation posted shortly. And we'll also send that new fact sheet to you in an email after the webinar today. So without further ado, I will turn it over to our first speaker, Andrea.
Good afternoon, everyone. My name is Andrea Centeno. I am the Regional Counsel for MALDEF's Washington, D.C. office. MALDEF stands for the Mexican American Legal Defense and Educational Fund, and we are a civil rights organization that represents the interests of all Latinos living in the United States. Next slide. So we are here to talk today about census litigation. And one of those cases is a case that was brought in Alabama by the state of Alabama to try and exclude undocumented immigrants from the apportionment count. This case was brought very early on, prior to any sort of word from the administration that it, that it was going to actively try to exclude undocumented immigrants. Alabama filed their lawsuit in May of 2018, so more than 2 years ago, in order to force the government to take out all undocumented immigrants from the state total counts that are used to apportion the U.S. House of Representatives and Electoral College votes. So there they challenged the 2020 residence criteria. And essentially that's the rule that says that, everybody is counted at the place that they live and sleep most of the time. And that rule includes everybody in the country, whether you are a citizen, a non-US citizen, or undocumented immigrant, you are included in the count of the resident population. Alabama argues that undocumented immigrants should be excluded from the total population on the basis that they, Alabama argues that they are not persons under the meaning of the 14th Amendment, and therefore were never intended to be included in the total apportionment count. MALDEF and others, including lawyers from the Lawyers Committee and a coalition of states led by New York State and others, intervened in that litigation to defend the residence rule and the Constitution, because there was little faith that the administration was going to be able to successfully and zealously defend the Constitution and defend the practice of including everybody in the apportionment count. Next slide. So some of the key issues here for this case, focus around whether or not Alabama should be allowed to bring this case, whether they can show that they will indeed be injured because of the inclusion of undocumented immigrants in the resident population, and that if you excluded them, somehow Alabama would be able to retain its 7th seat. The other issues center around whether there's actually something that Alabama could gain from this process, meaning is there a remedy to their injury here, and is it even possible for the administration to exclude undocumented immigrants from the apportionment count? These were issues that were, being discussed and hashed out early on in the litigation prior to the president's July 21st, 2020 presidential memorandum that we're going to talk about at great length today. But some of the other, issues that, were key front and center in this Alabama case, and that are today, because it continues, is really what is the meaning of a person under the 14th Amendment, under our Constitution. And when the Constitution requires the census to enumerate each person, the fact that you are tabulating a population for which you haven't asked immigration status on the census form, and that you have to find a different way to try to decipher whether or not an individual is a citizen, whether they are a documented non-US citizen or an undocumented immigrant. How do you do that? And is it an enumeration? Here, it's a clear violation of the 14th Amendment to argue that a person, who does not have a formal immigration status is not a person under the 14th Amendment. But in addition to that, it's clearly a violation of the Constitution to argue that you can somehow estimate or guess what the number of undocumented immigrants is in each state, and then remove that from the count, the census count that, that we just wrapped up in 2020, where the census sends every household a survey and counts every person in each housing unit. In addition, in that litigation, MALDEF filed a cross-claim against the federal government because we were afraid that the federal government would take this opportunity to try to affirmatively provide Alabama the relief it was seeking, that it would just go ahead and do some sort of removal of undocumented immigrants voluntarily. And unfortunately, that's where we have found ourselves today. The July 21st, 2020 memo is an attempt to do just that. Next slide. So this brings us to, MALDEF's other census case, which is La Unión del Pueblo Entero versus Trump. We brought it in the U.S. District Court for the District of Maryland. And this case actually started out as a challenge to the creation of a citizenship redistricting file. For those of you who are following the litigation around the citizenship question, MALDEF, along with our partners at Asian Americans Advancing Justice, our co-counsel in that case, brought one of the cases against the federal government for its attempt to add a citizenship question to the decennial census form. When the administration decided that it would no longer seek to add a form after it lost, and Sarah can talk about this, but after it lost in the Supreme Court, the president at that time issued an executive order that directed agencies to provide citizenship and immigration information to the Census Bureau so that the Census Bureau could work on building a set of data that states could possibly use for redistricting when it wanted to redistrict in 2021. And that data would come in the form of a citizen voting age population data file. So we challenged the sharing of that information and the creation of that citizenship file. And as we were going through our early stages of litigation and preparing for actual oral argument on the motion to dismiss by the government, the day before our oral argument was when President Trump issued his July 21st, 2020 presidential memo to exclude undocumented immigrants from the apportionment count. So our original case was allowed to then expand. We were allowed to amend our complaint, and we have since expanded it to include a direct challenge to the presidential memo and to also include a challenge to the shortening of the schedule for field operations and for post-processing of census data in light of the pandemic. The Census Bureau had announced that given the challenges of conducting field operations and making sure that it was doing non-response follow-up to all of the necessary demographics, that it was going to need more time to conduct the count and to conduct all of the necessary steps that come after they stop receiving census forms in order to provide accurate and complete data for the purpose of apportionment. Normally, those dates are, the apportionment totals, they are due by statute by the end of December. And then the president uses those numbers and turns them to, the U.S. House of Representatives in order to divide those seats. And so in this situation, the pandemic made it very difficult for the Census Bureau to do all of the non-response follow-up in the field. It wasn't going to be able to get people out to houses in the way that it had planned. And a lot of operations got pushed until later in the year because of the COVID-19 pandemic. But the Trump administration had, decided that it was going to issue the presidential memorandum, and sometime thereafter, the Census Bureau decided that it was going to stick to the original schedule to try and deliver apportionment numbers by the end of the year, even though it had previously said that it would need much more additional time and it wouldn't be able to deliver those numbers until the end of March. They did an about face and decided to move forward with their original pre-COVID plan, which means that there was less time for the Census Bureau to conduct non-response follow-up. And what we're finding in this position now, because the count ended on October 15th, is that the Census Bureau now has less time than it normally would have to do all of the post-counting, all of the post kind of data collection activities that it would do to make sure that it's got complete and accurate numbers for apportionment. And so we challenged the truncation of that schedule as well. We represent Latino, Asian American, and immigrant organizations and individuals across the country in that case. Next slide. So as I said, this was the Trump administration issued that executive order to collect all of this data about citizenship and immigration status when it decided to drop its bid to put a citizenship question on the decennial census. And the reason why the CVAP, redistricting file and this attempt to kind of collect all of this citizenship and immigration information was so critical, and why we brought this case originally in 2019 is because to carry out a redistricting scheme that leaves out non-citizens and leaves out everybody who isn't a voting age citizen in your area means that there are going to be communities who are going to be disproportionately affected. For Latinos, we are a disproportionately young population. We have high numbers of younger folks who may not be voting age eligible or who may not be US citizens. And it means that for communities like the Latino community, the Asian community, and others, if you have higher numbers of non-citizens in your demographics and in the areas where you live, you're going to lose out on representation for your community. And if you are a community that skews younger, you're also going to lose out on representation for your community. And so it was important to us that we bring this claim, under the Constitution, under the Administrative Procedure Act, in order to challenge what is an attempt to undermine the political power of a growing Latino base and a growing voter base of communities of color, as well as just kind of the, increasing diversity of our country. Next slide. And so one of the key issues when it comes to the citizenship redistricting file is how is the government really going to reliably figure out who is a citizen, who is a non-citizen, who is an undocumented immigrant. These are issues that are relevant to both the the citizenship redistricting file, and to the presidential memo in this effort to try to figure out how many undocumented immigrants live in the United States in each state. And so, as we look at the records that the administration has access to and that agencies collect, administrative records are just not reliable for producing block level citizenship data on which states can base their redistricting. The Census Bureau had made requests, and I'm sure some of you may have followed these news reports, where the Bureau asked states to share data like WIC and DMV records. To date, only 4 states have really agreed to provide that DMV data. But part of the problem is that when we think about DMV records, they're really inaccurate for the purpose of identifying non-citizens. It's old data. It's often not timely enough to really accurately reflect someone's non-citizen status today. And we look at something like, what happened in Texas when Texas tried to purge what it alleged were non-citizens from the voter rolls based on DMV records. They looked at old DMV records where someone, said that they were not a US citizen, and then looked at the voter rolls, which were not necessarily at the same time. They may have had years in between the 2 records. And they determined based off of this DMV record that someone on the voter roll was allegedly a non-citizen, which, was not true, because all of these people who were on these voter rolls had indeed naturalized in between the time that they had received their driver's license and then registered to vote. And so it's a good example there. MALDEF and others sued, MALDEF including Asian Americans Advancing Justice and many others sued, representing individuals who were about to be purged from the list based on those out-of-date driver's license records. But it's a good example of how administrative records are not able to really capture reliably someone's non-citizen status. And so the attempt to create a more detailed citizenship or immigration data file for the purpose of redistricting or for the purpose of apportionment really raises accuracy and privacy issues that are critical, that are critical and important for us to raise, and the reason why we're bringing litigation. Next slide. And in terms of kind of like what's the practical effect, why does this all matter when we're talking about our political representation? It's because we know that if you try to exclude undocumented immigrants from the apportionment count, for example, there are going to be states, those states that have higher rates of immigrants, higher proportions of undocumented immigrants. Those are often going to be states with greater diversity, higher numbers of Latinos living in them, higher numbers of Asian Americans living in them. And those are the states that are going to lose out on representation. And when you take that down to the redistricting level and using something other than total population to equalize the districts and equalize the population bases when you're redistricting for your state legislatures, it's also going to have a negative effect on the representation of communities that have high numbers of non-citizens and high numbers of children. And so we look at a memo that came out. It was a 2015 memo that came out in the course of the citizenship question litigation. And it really highlights why there is this attack, this assault on the census and on the data that the census provides, and this attempt to rig the apportionment numbers and rig the redistricting numbers against communities of color. And it really clearly is stated here in this memo. If you read it, Thomas Hoffler was a GOP consultant and worked a lot on redistricting. And he states that a citizenship question is necessary in order to get to citizen CVAP data, that citizenship voting age population data, and that to use something other than total population, if we were to use citizen voting age population instead of the total population to redistrict for states, it would be advantageous to quote Republicans and non-Hispanic whites. And so here you see the real motivation, the entire kind of reason for why we're finding these, why we're encountering these assaults on the census and the assault on kind of apportionment and redistricting norms, and the very foundation for who counts when it comes to congressional and state representation. And so, I'll leave it there to let my wonderful colleagues talk about some of the other issues that are at play. I'm happy to answer questions, but these are really critical issues for the Latino community, for the Asian community, and for immigrant communities and other people of color, because it is an attack on our political representation and our political power in the long term. And we have to be thinking about that kind of long-term, that long game that is being played right now, and how we're going to defend our communities in this kind of environment.
Andrea, thank you. Thank you for your thorough and detailed explanation of the arguments and challenges in this litigation, and for MALDEF's continued leadership and partnership in protecting the census through the courts and fighting back against repeated attempts from this administration to make our communities invisible. I will turn it over to our next speaker, who is my colleague, Eri.
Thanks, Bessie, and thanks, Andrea. So as Andrea mentioned earlier, we expanded our litigation with Advancing Justice AAJC along with MALDEF to challenge the latest attempts by this administration to undermine the census and hurt our immigrant communities of color. So those two things are the July 21st presidential memorandum on excluding undocumented immigrants from the apportionment count. And I'll let Sarah speak more about that issue. And then the second part was the truncation of census operations, as Andrea mentioned. And so we are challenging these two additional claims in our ongoing litigation. Next slide. Okay, and so in terms of the 2020 census operational timelines, so, as we all know, the COVID-19 pandemic has upended everything, including the Census Bureau's operational timelines. And back in March, which feels like a very long time ago, the Census Bureau suspended its in-person operations, they closed its field offices. And then in April, the Bureau announced their COVID-19 plan. And so the Bureau determined that it needed until October 31st in order to complete their count. Additionally, the Bureau determined that it needed additional time to report the final count for apportionment. So while the statute in Title 13 provides that the final count for the apportionment is to be reported to the President by December 31st, the Bureau announced that it needed until April 30th of 2021 to report that count, and that it also needed until July 31st of 2021 to deliver the redistricting count. And this, need for additional time was reflected by the quotes from career Census Bureau officials, including one official who said in May, recognizing that they were already beyond the point of being able to meet the statutory deadline and report the numbers by December 31st. But against that backdrop, on August 3rd, the Bureau announced that it was going to cut the census operation short by ending enumeration a whole month early on September 30th, and that they were going to report the final count by December 31st. And we later learned from court documents from the litigation in California that this plan, the truncated plan, was developed in just 4 or 5 days, and that stands in stark contrast to these, census operational plans that are typically developed over the course of a decade. Next slide. Okay, so why is truncation problematic? Why does it hurt our communities? So obviously, less time to enumerate means less time to self-respond. And then this also creates confusion over the deadline. And we know that in a census where clear and consistent messaging is so important to convince people to respond and to get out the count, this confusing timeline can further chill participation in the census. And this also affects the non-response follow-up or NUFR operations. And one thing was that due to the pandemic, the Census Bureau had struggled to meet hiring goals for their enumerators and having safety considerations for their enumerators. And then in addition to that, in trying to sort of address that, they provided incentive pay for enumerators to close out households and complete that count. But that raised accuracy concerns because enumerators were incentivized to just quickly close out cases. And then we also heard reports around the country about certain, area census offices closing early or other operational concerns on the ground. And as many of you know, this affected the Get Out the Count efforts by advocacy organizations who are already, addressing the COVID-19 pandemic and adjustments you had to make in response. But we know that less time to count made it harder to get out the count. And we know that these advocacy efforts and, having advocates on the ground who know the communities the best are the most effective at reaching individuals to get out the count. And then, so all of these concerns affect the data quality for what's been collected in the 2020 census. And then on top of everything, truncation not just has less time for enumeration, but also for what happens at the back end to clean up the data. And I'll talk more about that in a minute. Next slide. Okay, so how does this truncation affect the data for the 2020 census? So you may have seen the Census Bureau reporting that 99.9% of households have been enumerated. But this statistic tells us actually very little about the quality and the accuracy of the count. So for one thing, the 99.9% number is a national average. And we know that response rates vary greatly down to smaller geographies based on state, county, or at the census tract level. So self-response is actually a better number to look at when it comes to examining the quality of the data. So for one example, in Hidalgo County in Texas, where one of our organizational plaintiffs as well as their members are located, they had a self-response rate of 54.5%, and that was much lower compared to the national average of 67%. And we again know that these disparities can be exacerbated further at the census tract level. Additionally, we know that data collected through the non-response follow-up operations are less accurate than data collected through self-response, and that these operations have been complicated, as we know, by the COVID-19 pandemic, as well as the wildfires and the hurricanes. And of the households here that were enumerated through the non-response follow-up operations, this includes households who were enumerated through administrative records. So this includes like records from IRS data or Social Security Administration data. And we know that these records tend to miss communities who are traditionally harder to count. And these responses also include proxy responses. So proxies are when enumerators are not able to reach the household, so they interview a household's neighbors or landlord in order to close out the household. And we know that proxy responses are generally less reliable in terms of the accuracy and the quality of the data. And then the percentage of the households who are counted only tell us about the number of the housing units, instead about the accuracy of the count of individuals within a household. So this is called within household emissions, when sometimes certain individuals within a household might not be counted. And that could be due to a number of reasons. Sometimes households don't know that young children, such as babies, should also be counted. Or sometimes there are concerns about immigration enforcement if a household member is undocumented. So we, actually, can we go back? Thank you. So yes, we don't know how many of these, like within household emissions, there may be. A few other points. So this data about the 99% of households, that doesn't include everyone that lives in the United States, because it doesn't include what are called group quarters. So that can include college students living on campus, people at transitory locations, such as like RV parks and hotels, as well as individuals who are experiencing homelessness. Next slide. So this truncation of census operation is not just about less time to enumerate, it's also about having less time to process the data once the enumeration is completed. So now that the count has been closed, the Census Bureau is shifting their operation to what's called post-data collection processing, or post-processing. So what this means is that the Census Bureau is now going through their data and to try to identify any errors. And this is a very carefully sequenced series of steps that they go through, that they plan and test in order to ensure an accurate and complete count. So for example, one of the things that's traditionally done in post-processing is identifying duplicate responses. So when, for example, college students are supposed to be counted at their on-campus address, but sometimes college students can be double counted both at that address as well as their home address. And these processes have been complicated further with the pandemic, with a lot of students having gone home to their parents' address back in the spring due to the pandemic. And so it's really important that these duplicate responses be identified so that individuals aren't double counted. And this is also an issue for individuals who have second homes. So they could be counted at their regular residence as well as their second home. And this could cause a double count of those who are wealthier, who are able to afford these second houses. And that can further exacerbate any issues with disparities in the count. And then post-processing is also where the Census Bureau performs additional quality checks to ensure accuracy. And these are just some of the examples of why post-processing is so critical to ensure a full and accurate count. Next slide. Okay, so where are we now? The current status of census operations. So as many of you know, the enumeration process ended on October 15th. And how we got there was because in the litigation out of California, the judge had initially ordered that the Census Bureau needed to keep counting through October 31st to ensure a full count. But the government opposed and appealed that ruling, and then asked the Supreme Court to step in the meantime. And at that time, the Supreme Court cleared the way and allowed the Census Bureau to end its enumeration. But just because the enumeration is over does not mean that the census itself is over. So as I mentioned earlier, post-processing is the important part of the census to ensure accuracy. And the Census Bureau is currently working on that process. And currently the reporting deadline is December 31st. But as I noted earlier, the Census Bureau in the past has recognized that on multiple occasions that there's just not enough time to meet that deadline. But currently, the Bureau says that they are working to process this data to deliver the state population counts as close to the December 31st deadline as possible. And the Bureau has provided very little information on how it plans to do this. It initially set aside 6 months to plan to do this, and now it's planning to do it in 2.5 months. So they've provided some little bit of information, such as they are doing some of the data processing to produce the numbers for the presidential memorandum until after it reports the apportionment count. But beyond that, we don't know a whole lot about what the Bureau plans to do and how it plans to get close to the December 31st deadline. So this is why ongoing litigation by Advancing Justice AAJC and MALDEF and others will shed light on necessary next steps to ensure a complete and accurate count. Next slide. So how does this affect our Asian American, Native Hawaiian, and Pacific Islander community? The truncated enumeration, the post-processing, and the data quality issues just mentioned are all likely to disproportionately affect the accuracy of the count for traditionally hard to count communities, including immigrant communities of color. And the data quality and accuracy at the local level is so important so that resources such as funding for schools and hospitals and roads are allocated fairly. And not only does this data quality and accuracy affect these funding and resources issues, but it also affects the political power and political representation of our community. So it's again critical that the Census Bureau has adequate time to process the data. And we know that the consequences from this census will last a decade. Next slide. As I mentioned, Advancing Justice AAJC and MALDEF continue to advocate and challenge these issues in court and to ensure a full and accurate count. And I think we are also working on a fact sheet for some summary of some ongoing issues at stake in this litigation. Bessie?
Eri, thank you for walking us through the census operational timeline and all the changes that were made with the COVID plan and the truncated plan and what the misleading enumeration data actually means. I know that so many of us on this webinar have been working tirelessly to make sure that our communities can be counted fully and accurately. And our communities are historically undercounted, like you said, and census data impacts our resources, our power, and our voice for the next 10 years. So it's so important to get accurate data. And everyone, you will be seeing our new fact sheet posted soon. And again, we will share that with you via email as well. Without further ado, I want to turn it over to our last speaker, Sarah with ACLU.
Hi, everybody. This is Sarah Brandon. I do not have PowerPoints like my colleagues who just did very lovely PowerPoint presentations, but I'm going to give you a little bit of background and information, building a little bit on some of what Andrea said also about the ongoing litigation related specifically to the president's memorandum. So I assume everybody knows in the end of July, the president issued a memorandum basically instructing the Census Bureau to give him information so that he could exclude all undocumented individuals from the apportionment count, which is basically the census population count that is used to allocate the House of Representative seats. And every state has a different number of House of Representative seats depending on their state population, and the decennial census is the source of that information. That allocation is done through a formula that is in the Census Act. It's a statute that's been in place for many, many years. So the math is pretty straightforward in terms of how the seats are allocated. But obviously you have to have an accurate census count of what the population is before you do that. I think it's really important just to understand the sort of historical unprecedented nature of what the president has asked to have occur. We have been doing censuses in the United States since the 1790s, and every single census since the 1790s has included all individuals who are residing in the United States, regardless of their legal status. So the idea that you might exclude people who do not have documentation, who are living in the United States is, would be an unprecedented change of over 230 years of American history and practice. The Census Bureau does have a statutory provision that establishes something that's called the residency rule. So I think the thing, and that's kind of important to understand, again, how sort of just completely unprecedented what the president is doing. So the residency rule, which is also, been around and been applied going back, I'm not sure the history of how far back, but, at least since the 50s, if not all the way to the 1920s, which is when the current version of the Census Act was passed, sort of defines what it means to live in the United States. So it's a statutory provision that's been developed some in the regulations to define what it means to live here. And that does not include any characterization or any evaluation of a person's legal immigration status. It really is looking at things more like whether they're here permanently or here transitory. So the residency rule is the reason why a tourist, for example, is not counted in the census, but somebody who's been in the United States and basically has an intent to live and reside here in the future. So there is a standard that's already in place to account for who is really living in the United States and what's the definition of what it means to be living in the United States. And that is the rule that has been used to define who should be counted in the census, which is basically anybody who is residing here. And it has never included any element of that evaluation, has never included any element of evaluating whether somebody has legal status or not when they're here. So it's quite a change. And then I think the other important part about the presidential's memorandum that's really important to understand, and then I'll get a little bit to the actual posture of the lawsuit that we filed about this memorandum, is it's also just a horrible example of how much the current administration has politicized the census and completely disregarded and ignored the advice and guidance of the career people who work at the Census Bureau. The Census Bureau is an extremely well-established, internationally well-respected organization that's been around for a number of years and has strived to create a very professional approach to how the census is conducted. Many of the world's leading experts on surveying and statistics and the processes that one goes through to do something like a census count are employed and work for the U.S. Census Bureau, and they strive to do the best they can to come up with the best and most accurate census and to stay out of politics and to not be involved in these sort of partisan circumstances that we unfortunately have seen ourselves in dealing with the census the entire last several years with this administration. And just to give you some context, the presidential's memorandum was dated July 21st. It was leaked to Politico on the Friday, I guess, of July 21st, and provided to the Census Bureau staff formally the next Monday. So the current director of the Census Bureau, Stephen Dillingham, testified under oath before the House in late July that he did not know that the president was proposing this memorandum to ask for data to allow apportionment to exclude undocumented citizens until he read about it in Politico. So nobody in the administration, none of the political appointees who are in the Department of Commerce, which oversees the Census Bureau, had any communications with staff at the Census Bureau about what was possible, what information they had, what could be done, and how potentially even this could be implemented, not to mention what impact making a last minute change like that, an unprecedented last minute change like that might have on the quality of the census. And I just share all of that information, which is not specifically relevant to the legal issues, but just to give you some context of how outside the norm of these things the current administration is, the current administration's actions have been in terms of how they have handled and approached the 2020 decennial census. After the presidential memorandum was issued, you know, there were a number of lawsuits that got filed. The ACLU was one of them. We filed a lawsuit in the Southern District of New York with co-counsel of the New York Attorney General. This is the same team that litigated the citizenship question case in 2019, and our case was the one that made it to the Supreme Court in 2019. And so it's sort of the same group of folks. We have slightly different lists of plaintiffs. The ACLU represents the New York Immigration Coalition, Make the Road New York, CASA, the American Arab Anti-Discrimination Committee, FILA of Houston, and ARFA. I'm not sure if I'm saying that's right. It's a Korean group for justice. It's AAHPI. I assume there are folks on this call who could enunciate that correctly. We are representing all of those groups in this litigation. We filed a lawsuit alleging that the president's memorandum violated both the Census Act and the U.S. Constitution. The U.S. Constitution is pretty clear. It's the Census Clause that in the Constitution, Article 1, Section 2, Clause 3, that specifically states that the whole number of persons shall be counted in the census. And so our allegation is that the president's memorandum of excluding undocumented individuals is in violation of the census of the enumeration clause, which is the census clause in the Constitution, because it talks about whole persons and makes no characterization about what different persons you might include. Everybody who's residing in the United States. That's also very clearly what the Census Act says. The Census Act, the most important part of it that is relevant to this particular case, was passed in the late 1920s after the 1920 census, which was sort of a bit of a debacle historically also. And the Census Act is also extremely clear that you should count all individuals. So our allegation is that by excluding undocumented individuals from the census, there are a number of harms that are caused, but one of the harms that would exist is apportionment. Basically, that people who live in states with large immigrant populations would get less House of Representatives seats if their undocumented populations are not counted, and that would cause injury to everybody who resides in that state. Our clients all have people who reside in the target states. If you were to exclude undocumented individuals based on best estimates of how many people there are and where they live, most likely that would affect apportionment in California, Texas, and probably potentially Florida also. Texas, it's a virtual certainty. Our expert in the case said 99% chance that Texas would lose a House of Representatives seat in apportionment if undocumented individuals are not included. So we allege that that was the injury that was caused by the president's memorandum. And in our case, the district court, because we alleged claims about apportionment, which has to do, as I said before, with the House of Representative seats, the district court decided that we needed to have a 3-judge panel, which is pursuant to a federal statute that says when you raise claims related to apportionment, you should have a 3-judge panel. So we ended up with a 3-judge panel with our judge, who is the district court judge, who is also our judge in the district of second district. So it was the same district court judge that we had in the citizenship question case. And then he created a 3-judge panel with 2 Second Circuit appeals court judges. And we had argument before the 3 of them. And then that court issued an opinion declaring that the presidential's memorandum very clearly violated the Census Act. That court did not reach the constitutional question because they decided, having found that the memorandum very clearly violates the Census Act, it wasn't necessary to reach the constitutional claim. And they enjoined the president from excluding undocumented individuals from the apportionment calculation. That is the case that then the DOJ and the federal government appealed. And so that case is now before the US Supreme Court. The Supreme Court issued an order last week setting up a expedited briefing schedule and scheduling an oral argument and making it clear that they wanted to entertain both some jurisdictional questions which relate to whether or not our plaintiffs have standing to bring the claims at this point in time, but also to the merits. Does the presidential memorandum really violate the Census Act or not? So briefing on that will be done before Thanksgiving. And then the oral argument is now scheduled for November 30th, which is the Monday after Thanksgiving. So that's sort of where we are. And I guess we'll wait and see. It's very hard to know what it means. I mean, the Supreme Court, did grant cert and obviously ordered an expedited briefing schedule. They could have just let the 3-judge panel's opinion in our case stand, and the president would have remained enjoined from being, from going through this effort of excluding undocumented aliens from undocumented individuals from the apportionment calculation. The other thing, just to give people an update, is that of course there are a number of litigations that are going on. You heard Andrea talking about the MALDEF litigation, and one of the other cases that's pending is in California. There are a number of plaintiffs in that case, but the lead plaintiff is the city of San Jose, which I assume most people know has one of the highest immigration populations in the country. They also have a 3-judge panel, which is made up of a district court judge and 2 judges from the 9th Circuit, and they issued that court issued a 90-page opinion last night, which I don't think it's fair to say we've had an opportunity to digest. But what's interesting is that court's opinion found both that there had been a violation of the Census Act and also that there had been a constitutional violation, that the presidential's memorandum violates the enumeration clause of the US Constitution. We don't know what's going to happen next, based on what the US Supreme Court did in 2019 when there were sort of also competing cases going on. It wouldn't surprise me at all if the Justice Department asked for the cases to be combined and for that case also to be expedited and then heard at the same time as our case, given that there's already an oral argument date that's been scheduled. And if maybe that doesn't mean we would then have a Supreme Court that would address both the constitutional claim and the Census Act claim. So that may happen. It hasn't happened yet today. We're not totally sure. In our case, because we allege the constitutional claim in front of the district court case, the 3-judge panel with the district court judge, the constitutional issue is still live in that case, even though the district court panel didn't actually issue an opinion on it. So it's just not clear exactly what the posture of the different parties will be. There are a number of other cases. And one thing just to sort of flag for people to understand, our case and the case even in California, though it seems like maybe they reached a slightly a broader ruling than our district court judge did. Our injury was based on an allocation of resources having to do with counterbalancing the impact of the presidential memorandum during the census count. So it's not clear what that means now that the counting has stopped. And the Department of Justice has argued that they think our case is moot, that we no longer have standing because our injury was articulated in relationship to work our clients were doing to impact the counting. So it's possible that there will be a question before the Supreme Court that the Supreme Court would take very seriously as to whether or not our plaintiffs actually have standing now that there is no more census counting going on. We don't totally know that. But it's also one of the reasons I think it's important in these kinds of really fundamental cases where you have such a dramatic change in historical precedent. You have a president who's doing something that's so clearly unconstitutional, so clearly motivated with a racial and racist intent to exclude undocumented immigrants from the population count and to really damage cities and states with large immigration populations. I mean, the actual presidential memorandum itself, it doesn't say the word California, but it very clearly, the president was talking about California, and the DOJ has now admitted in hearings before several of these different cases that are pending, that the president's goal is to exclude undocumented individuals from the apportionment count to punish the state of California, because California is one of the places that would lose a congressional seat otherwise. So that is clearly his goal and his intent. It's so, so unfortunate that that's the place that we are. But it's very valuable, I think, that we have all of these different groups working together and all these different litigations going on, because it's just not 100% clear what is going to be the right pathway to stop the president. So I had somebody describe this to me recently, that we're all sort of running towards the finish line, and we all need to keep running until we are effective in permanently stopping the president. And everybody should keep running, because it's not completely clear what will hopefully prevail in the end. And we need to do everything that we can to try and prevent this from happening. So I know we probably want to leave a few minutes for questions, and I probably have talked too long. So I will stop now and let us answer a couple of questions.
Sarah, thank you for walking us through the details of the argument, where we've been and where we are with the Supreme Court. I know that all of us will be paying attention to the outcomes in all of these different cases, and we look forward to further updates from ACLU on your litigation. We are going to move to Q&A now, so I will turn it over to my colleague, Rima, who will be facilitating Q&A. And again, please use the questions box, the Q&A box to submit your questions, and we will be able to go through the questions there. And as a reminder, we will be sending a copy of the presentation and the recording to everyone following the webinar. And I'll turn it over to Rima. Thank you.
Great, thanks, Bessie. And thank you so much to our speakers for sharing your wealth of knowledge. So as Bessie said, you can either enter your questions into the Q&A box or the chat box. We already have a couple questions lined up, so I will start with Cynthia. Cynthia asked, when will Lupe versus Trump be decided by the Maryland District Court? And I can, Andrea or Eri, if you want to take that question.
Sure, I can take it. So we are pretty early in our case on the various challenges. So on the citizenship redistricting file, the issue there, we had been teeing up, and we were going to argue a motion to dismiss. The government had filed a motion to dismiss, and we were going to argue, in opposition to that. But much of that has really taken something of a backseat as we go through these other components. So, we had filed a temporary restraining order to try and extend the field operations, the count itself, and to also extend the, post-processing period for the census operations. There we were denied as moot, because by the time, recent developments kind of like played out and caught up to us, it was a little bit too late. The count had already ended in the other case, and the Supreme Court had already, allowed the Census Bureau to end operations on October 15th. So after that happened, we got our decision with, something of an invitation to come back with, if we needed to, or if we wanted to come back, given the new kind of space we were in and the replan. Or whatever altered plan the Census Bureau was going to use in post-processing period, given that the count had ended on the 15th. So we don't really have a firm idea of how quickly our litigation is going to move relative to the other cases. We're not in the same posture as the case that Sarah talked about in New York, as the ACLU case, or as the California cases. And so, this is an example of what Sarah mentioned, different cases moving at different periods of time and taking advantage of kind of those different, like where we are situated, and trying to kind of continue to push to get relief for our communities.
Great, Andrea, thank you so much. So our second question is from Lisa. Can Sarah say something about the administration's defense? What are the merits of the Franklin versus Massachusetts cases?
Sure. So what the DOJ has been arguing is that because of the Franklin, Massachusetts case, that holding in that case basically gives the president unlimited discretion to do whatever he, or we should say she, hopefully the world will be different someday, wants to do about apportionment. So I don't know if people know, the Franklin v. Massachusetts case was a case that was decided, I think, in 2005. And in that case, the fight was about how to count military voters and where they should go, whether they should count where they are living as part of their deployment, or where they should count where they are, where their home state is. and the president wanted something different. And so there was a sort of discussion about what's the best way for the president to influence the decision that's being made by the Commerce Department and subsequently the Census Bureau under the Commerce Department about where to put those individuals. And the language in Franklin v. Massachusetts is strong that the president can do whatever he or she wants in terms of apportionment. But our belief is that that case is not definitive in answering this question, because the question that was before the court in Franklin v. Massachusetts was a policy question that was a legal policy question. There was nothing illegal that was being advocated, like where to include the military personnel is a policy decision that does not implicate any other concerns. It's not barred by the Census Act. It's not barred by the US Constitution. And our belief is that the current, it's our belief, and we were able to convince the court in the New York proceeding, and the court in the California proceeding was also convinced that it doesn't have any bearing on what is going on right now, because what the president wants to do right now is to implement an illegal policy. So this is not a question about the president's discretion to make decisions about policy. That may be an issue that we can live to fight a different day, but we don't have to resolve the scope of the president's discretion to make policy related to the census in this particular circumstance, because what the president is proposing to do is illegal. It violates the Census Act, it violates the US Constitution, and on top of that, I think it violates the Fifth Amendment, because it's also motivated by an intent to discriminate based on race. So between all of those reasons, for all of those reasons, what the president is doing is illegal and is clearly not allowed, even if he or she has a fair amount of broad discretion. They don't have discretion to violate the US Constitution.
Great, thank you so much, Sarah. All right, I think we have time for 2 more questions. So this one is from Anita. Does the memo also explicitly indicate undocumented immigrants aren't to be included for the redistricting file?
Sure, so I can take that. If, the presidential memo deals directly with congressional apportionment. The effort to create a citizenship redistricting file really emanates from his 2019 executive order that directed agencies to share information with the Census Bureau, and then a directive from Secretary Ross to the Census Bureau to create a data file, a citizen voting age population data file with that information for the purpose of states to use for redistricting. That was the language that was included in kind of the directive to the Census Bureau. And so by virtue of the fact that it would exclude anybody who's not a citizen, it would exclude anybody the only people who would show up in this potential data file would be citizens of voting age. So you'd have to be a citizen and 18 or older, meaning it then will not include, it won't include non-citizens, even if you are, a documented non-US citizen. So even if you are an LPR, you wouldn't be in the data file, and it wouldn't include undocumented immigrants. It also wouldn't include anybody under 18. So if you are a US citizen, but a child, you would not be in that data file. So if they try to, if a state tries to redistrict off of a citizen voting age population data file, there are going to be a lot of people who are not going to be included. And it's not just non-citizens, it would also include some US citizens who just are not voting age based on that administrative data, which may or may not be correct.
Thank you, Andrea. And to be mindful of our speaker's time, we're going to take one more question. This is from Susan. If the Senate and White House become controlled by the Democrats, is there the ability post-January 2021 to revisit/redo apportionment?
So I can speak to that. The real answer is nobody knows, because it's never happened before. And what this looks like, nobody knows. I think the one piece of information that would be helpful to share with you guys is that there is currently a bill There's a bill in the Senate, there's a bill in the House. This bill in the Senate has bipartisan support. Alicia Murkowski, the senator from Montana, have supported a bill that would extend the census deadline. So it would put off apportionment until the original proposed date under the COVID rescheduling. So that would be April of 2021. So that bill does exist. It does have bipartisan support. And there is an effort going on right now to get Congress to pass it. It was originally included in the COVID relief bill that the House passed in May, I think. And now, of course, there's all these ongoing conversations about COVID relief. It's not clear if it would be included in part of that or not, but there is hope that maybe. So people should be aware that there is an effort to try and persuade Congress to pass a bill, either as part of some relief packages that get passed in the next month, or as a standalone bill to push the apportionment and calculation deadline back to April as the census originally intended. And I think that's important to think about because the dynamics of whether that's possible may change in a lame duck in December. And I think the conventional wisdom is, until the day they actually deliver their numbers, at any point Congress can pass a law that says they have 3 more months and then could go back and keep working on those numbers. That might have then avoid the necessity for them to implement the presidential memorandum, depending on who was president in April. And not to mention, it would address all of the very concerning quality control issues that Eri laid out if they had 3 more months. It's not perfect. It's very just unfortunate they didn't get to keep counting, but there's still so much work that they need to do. And if they got more time, the Census Bureau could work on some of those things that would only help to improve the quality of the data.
All right, so I see that we have a few questions and we will share our contact information for our speakers in this slide, but also in a follow-up email when we send out the recording and the presentation. A huge thank you to all of our speakers today for sharing their knowledge and walking us through all these complex details of litigation. And thank you everyone for being on this webinar with us and for all the work that you've done to ensure a full and accurate count of our communities in the 2020 census. With that, I will end our webinar and I wish everyone the best of luck with their work, and we look forward to sharing updates with you.